My name is Thomas Lindsay, and I'm Senior Counsel for the Center for Democratic and Environmental Rights. We're here today talking about the 4 legal doctrines that interfere with people doing work at the local level to expand rights for or protect the natural environment and the community. So right now we're going to talk about preemption, which is the first side of the box, and it's a doctrine that people run into the most when they attempt to do this local or municipal lawmaking. Because the state authority to preempt or prohibit that lawmaking is an obstacle that people run into first. So the question we get a lot when people work at the local or municipal level to begin passing environmental protection laws is they run into this thing called preemption. And they come to us and they ask, what is this legal doctrine of preemption? And essentially it's about higher governments prohibiting lower governments from passing certain kinds of laws. And so the federal government can preempt state governments from passing certain types of laws, and state governments can preempt local governments from passing certain types of laws. How does it work in practice? Well, in Colorado, for example, they have a state oil and gas act which specifically preempts communities in Colorado from banning fracking. So this is hydrofracking for natural gas and all the problems that flow from that practice. That when localities attempt to pass something more stringent than what the state has in place, in this case the Oil and Gas Act at the state level, that the lower governments can be overturned. In other words, prohibited from adopting certain laws at the lower level that adopt more stringent environmental standards than at the state level. In Pennsylvania, you have the same thing, which is a state oil and gas act which controls communities, what communities can pass in terms of banning or regulating oil and gas extraction and the placement of frack wastewater injection wells and other types of facilities. In Florida, you have a situation where folks have attempted to adopt local laws recognizing legally enforceable rights for ecosystems and rivers and bays there. The Florida legislature has now introduced laws to ban and prohibit the passage of those local laws at the municipal level. And it's not just environmental laws. You have preemption laws that deal with plastic bag bans, affordable housing, gun control, basically prohibiting people within those municipalities, within those states, from adopting those kinds of laws. Now, a lot of folks assume that when you pass a law that's been preempted, it's the state government that comes in and says you can't do this. But it's not. It's actually large economic actors like corporations that come in who use the preemption laws that have been passed by the state legislature to sue in private forums, i.e. Federal court and state court, against the municipality that has passed these laws. So a lot of folks think this is a state action kind of thing, but what really happens is the state sets the stage, and then large corporations come in, actually use those laws to sue to overturn the laws that have been passed at the local level that set these more stringent environmental standards. And then the next question, of course, is what do we do about preemption? Well, it's important to understand that when state legislatures enact preemptive laws, that they're acting beyond their authority to do so, that they're acting unconstitutionally. All state constitutions have provisions in them that say people are the source of all political authority. Either that's true or it's not. But at the municipal level, either people within the community are the source of that political authority, or it's the state legislature. And when the state legislature adopts preemptive laws that prohibit municipalities and people within them from passing certain environmental protection laws, that they're operating contrary to the state constitution. They are, in essence, violating the constitutional rights of the people in those municipalities. So the argument we make as lawyers in these cases is that the municipality and the people within those communities have a right of local community self-governance, a constitutional right that flows from their state constitutions. And that what they're attempting to do is expand or grow above the floor that's provided by state governments when they adopt environmental protection laws, and that municipalities and people can go beyond that, and that the state violates their constitutional rights when the state attempts to preempt them in those areas. So it may sound like a fairly radical idea that communities can say no to pipelines or frack wastewater injection wells or ban certain things that are harmful to their community or to the environment, when in reality it's not that radical at all. For the past 80 years, we've had a relationship between the federal and state government in which state governments can expand constitutional rights at the state level above and beyond what the federal Constitution provides. So in some ways, all we're talking about doing is taking that federal-state relationship and normalizing this state-local relationship. But it's certainly not new law. It's not novel at all. It's been the relationship between the federal and state government for the last 80 years.